I think it's a mistake to feel like you've got to rebut every single thing that the defense says, and because what happens is it becomes more about them than about the case that you've put on, and so I don't think that you have to do that. But I think what you want to do is pick some things that, as you're rebutting them, what you're really doing is showing that they're being gamey, that they're being unfair, that they don't deserve the credibility in the case, that they're trying to mislead the jury, that they're not worthy of being followed.
The thing about what's going on here is life expectancy. I don't have any idea. I wish I could look into each of you and say, where are you right now? How can I help you? I can't do that. I gotta make assumptions. You know how you can tell what's appropriate? First of all, from the stand, if you remember, I said I use this chart. He says I use this chart because it's sanctioned by the courts as being appropriate. You're going to hear the court give you a charge that says it's appropriate to use that chart. But nobody here knows. So you guys are going to have to wrestle with that in terms of life expectancy. All right. But however you do it, we trust you to do it because there's no better way that I can think of to present it to you. If we didn't bring you the evidence, we'd be criticized for not. And so hopefully we give you the tools to do that. But if they want a discount because because Ms. Johnson's not going to live as long because they injured her brain, that doesn't seem right either, does it? The time you start to evaluate what the quality of life is not when she's in the condition she's in now. The compare and contrast point is what she was like before she fell. Who was this woman before she fell? How full of life was she at that point in time? Not where she is now. We all know where she is now. We all know that her quality of life is horrible now. And I don't know what to do with that. And you will wrestle with that too, undoubtedly. If this is all we can do is come here.
One thing you notice in there that at one point I said something like, you know how you can tell if this is right or not? Listen to the jury charge, listen to the judge. What we're looking for in these cases is credibility. We're saying we're credible, we're saying they're not credible. So sometimes we want a little bit of sort of vicarious credibility. And the way we can do that is by pointing to the charge. Okay, you'll know this is right because you'll hear it come from the judge explaining the charge. Here, we were getting beat up on, they were trying to say it was a shorter life expectancy than we were saying. And the last piece was to kind of flip that at the end and say, look at what they're trying to do here. They're trying to say they deserve a discount because they hurt her so bad that her life should be worth less because they hurt her. And so pointing that out to the jurors, we've had that in a couple of trials, Michael and I have, and it's funny because somehow we lose that as plaintiffs lawyers a lot of times, is we forget that point. And it's so poignant because they shouldn't get a discount. Then it's like, shouldn't they be adding a wrongful death component? Should the numbers be even higher at that point in time? And you can watch the jurors go, heck yeah, that's exactly right. So that's the way we would use something like that. Anything to add, guys?
Yeah, no, I mean, if you are going to, and so basically what's going on is, the annuity mortality table gives you X number of years, which is what everyone uses. And then you say, well, look, this person's got a bad injury. As a result, their life expectancy is reduced. They're not going to live that full lifetime. And therefore, your life care plan is overvalued. But if your life care plan is overvalued because you're going to cut off the last 10 years of their life, then you got to pay them for the last 10 years of their life, which should be more than what the life care plan would be for 10 years. So, you can argue those things left and right. It's those things that that defense lawyers like to talk about that are great technical arguments. Juries look at people like, I can't believe that guy argued that. Right. So, don't fight it. It's a gift. Enjoy it and use it for what it's worth.
Yeah, Michael did. And there's another trial. If you haven't watched it, you can watch the Kahn trial where that issue came up, and the defense brought a witness from Seattle, I think, who was a quote like the life care plan. I mean, the life expectancy guru of the freaking world. And Michael's cross of that guy was literally like 3 questions. It was like, are you here to try to suggest that, ladies and gentlemen of the jury, that the defense should get a discount because they reduced the life expectancy of our guy by 8 years or 10 years or whatever what it was? And he looked at Michael and said, yes. And, and it was almost like, okay, thanks. I mean,
Right.
because it was all a setup for the closing argument.
Joe,
So-
I do want to say,
Yeah.
I think you said it most. I remember that trial and watching your second close on that, and the defense in his closing said, I think he asked for $25 million on that case, and he said, if you believe our expert, this case is not a $25 million case because he's going to not have the life expectancy that they say he will. Joe got up in closing. He goes, I agree with the defense on one thing in their closing. He goes, I agree that if you believe their expert, that this is not a $25 million case. He goes, in that case, it's a $50 million case because they've killed him 10 years early. And I thought that was, and then you just dropped it and moved on, but it was the great way to address that very quickly.